Hello, everyone, and welcome to Uncivil Law. And for today, I've got a spicy one. The U.S. Supreme Court has just agreed to hear a case dealing with conversion therapy as it relates to children. So this is the idea that you can go to a psychiatrist and have them try to convince a child, in this case, to not be LGBT, and perhaps treat them out of that and try to get them to not be LGBT, which is controversial to be sure. I believe California was the first state to ban conversion therapy quite some time ago. It's been a hot minute. And we are now coming out of Colorado, ironically enough, I suppose, relating to this same issue about whether or not it's okay to have a law that bans a therapist from essentially trying to convince, I suppose, a child not to be LGBT. Can you have a law that prohibits the therapist from giving that therapy? So that's pretty spicy. We are in the case of Childs versus Salazar out of Colorado. And we will just read the question presented because it pretty much lays out, well, we're going to read more than that, but we'll get started with the question presented. Kaylee Childs is a licensed counselor who helps people by talking to them. A practicing Christian, Childs believes that people flourish when they live consistently with God's design, including biological sex. Many of her clients seek her counsel precisely because they believe their faith in their relationship with God establishes the foundation upon which to understand their identity and desires. But Colorado, and Colorado is not unique in this domain, Colorado bans these consensual conversations based on viewpoint they express. Its content and viewpoint-based counseling restriction prohibits counseling conversations with minors that might encourage them to change their sexual orientation or gender identity, including efforts to change behaviors or gender expression, while allowing for conversations that provide acceptance, support, and understanding for identity exploration and development, including assistance to a person undergoing gender transition. All right, that's really, really interesting to me legally, because we now might get into potentially a difference between content-based regulation and viewpoint-based regulation as it relates to this. And the only case that really sort of seems to be on point relating to this, perhaps ironically, perhaps not, is the flag burning case. And in the flag burning case, the US Supreme Court seemed to imply that while content-based regulation is strict scrutiny, they seem to imply that at least it's possible that viewpoint regulation is per se unconstitutional. So you would actually therefore it would not be possible, right? That would be the thing. It would be per se unconstitutional. So we might actually get into whether or not this is strict scrutiny in which it's basically impossible, or is this viewpoint scrutiny? And if so, are we up at this elevated standard, which we've gone from basically impossible to just actually impossible? And here they're highlighting that difference because they say, okay, this isn't just I can't talk to them about their gay feelings, right? That would be subject matter based. It's like you can't talk to the kid about their feelings about being gay, right? If that was the rule, it would be content based. But they're making the stronger argument here, which is not unwarranted and not unwarranted. It's like, no, it's worse than that. It's worse than content-based. I'm specifically allowed to provide for acceptance, support, and understanding and assist a person in undergoing transition. So I'm allowed to encourage it, but I'm specifically not allowed to discourage it. And so that's very, very interesting from a legal posture, because like the bare minimum is strict scrutiny. And depending on that one case, like the flag burning case, it might be per se unconstitutional. So yeah, that's dynamite, man. That's dynamite fuel. Okay. The 10th Circuit upheld this ban as a regulation of conduct, not speech, which for a talk-based therapist, that seems challenging, that this is conduct rather than speech. I'm a talk therapist. So what's exactly the context here? It's not clear. In doing so, the court depended on a circuit split between the 11th and 3rd Circuits, which do not treat counseling conversations as conduct, and the 9th Circuit, which does. So the 9th Circuit has treated this issue as conduct. And so the question presented is whether a law that censors certain conversations between counselors and their clients based on viewpoints expressly regulates conduct or violates the free speech clause. Wow. I mean, I think you gotta favor them from the outset. It's like I think you gotta favor them from the outset and be like, this is probably right. It's like, yeah, this is probably right. So I think this law is probably not long for this world. So conversion therapy, I think, is back on the menu, boys. And the Supreme Court decided to pick this up. This is in no way going to be controversial, right? This is in no way going to be controversial. So they'll probably hear oral argument on this. It's May. They're definitely not going to hear it this year. They're probably going to hear oral argument on this, like in October or November. And they're going to have a decision probably by March of next year. So from a year from now, right? A year from now, it's like we're going to have a decision on this. I'm like, wow, guys, it's going to get pretty spicy, man. It's going to get pretty spicy. Okay. Let's how do I want to go about reading this? How do I even want to go about reading this petition, which has been granted? All right, let's see. All right. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish. That promise protects every viewpoint, no matter how controversial, and encompasses the layperson and professional alike. True enough, right? The Supreme Court sort of, at least with lawyers, rejected that distinction quite a long time ago, or at least said professional speech is, just because it's professional doesn't mean that it can be infinitely regulated. Over 20 states and 100 localities have enacted laws that silence counselors' ability to express views their clients seek on a topic of fierce public debate, how to best help minors with gender dysphoria. The 11th and 3rd Circuits have rightly concluded that such laws regulate speech. But the 10th Circuit has now joined the 9th in blessing censorship by labeling counseling speech as conduct. The court should not allow this conflict to persist. Otherwise, counselors like Kaylee Childs and countless other professionals who provide personalized services, who are subject to a licensing and regulatory scheme, will have First Amendment in some states, but not others. This 2-to-2 circuit conflict can be traced to lower circuit confusion over this court's precedent. In Holder versus Humanitarian Law, this court held that even laws that generally function as regulation of conduct still silence speech if they target a message. And in NIFLA, this court affirmed that this test applies to professionals. Governments do not have a freer hand to regulate speech simply because the speaker is licensed or giving specialized advice. But rather than consider what the laws regulate, the 9th and 10th Circuits insisted on speech continuum that looks at who is speaking. That doesn't make any sense. Not under the current law it does. That would have made sense 30 years ago. But I don't think that makes sense now to look at it as a continuum. Yeah, that's interesting, man. That's interesting as hell. The 10th Circuit cramped view of NIFLA has devastating real-world consequences. In jurisdictions with counseling restrictions, many young people cannot receive the care they seek and critically need. Wow, yeah. Such restrictions have left some clinical staff fearful of providing professional support to young people at all. That leaves detransitioners who adopt a transgender identity but now identify with their biological sex with no counseling support whatsoever in much of the United States. Wow. Yeah, wow. I think they're right. I think what I'm going to do here, I'm on page 15 of this. I think what I'm going to do is I'm going to skip to the 10th Circuit decision before I read too much more, and try to assess it as best as I can, as neutrally as I can. And the 10th Circuit decision looks like it goes on for a while. So this is going to be challenging, but I'm going to skim it. All right, so what is this? Is this the decision from the 10th Circuit? I think this is. Because they attached it as an appendix. Okay, so it's in the appendix. All right, cool. All right, so now let's turn our attention briefly to the 10th Circuit Court of Appeals in their decision. So we sort of know that we know the framework. All right. So Colorado law says you may not engage in conversion therapy with a client under 18. Conversion therapy is defined as any practice or treatment by licensee, registrant, or certificate holder that attempts or purports to change an individual's sexual orientation or gender identity, including efforts to change behavior or gender expression, or eliminate or reduce sexual or romantic attraction or feelings to individuals of the same sex. Conversion therapy does not include practices or treatments that provide acceptance, support, and understanding. Yeah, dude. I mean, like, dude, that's pretty viewpoint based. I mean, I don't know how you can not say that's viewpoint based, right? You can't do efforts to reduce sexual attraction or feelings, but you can do acceptance, support, and understanding. That feels really unconstitutional. That feels amazingly unconstitutional. Anyone engaged in the practice of a religious ministry is exempt from complying with the law, but not for other kinds of therapists. Okay, so that seems really illegal. All right, so we're going to skip a lot of this because I'm interested in sort of the punchline relating to how this is conduct. Yeah, is she subject to the regulations? We say that she is. Has she stated a present desire? Does she have standing? We're going to pull up best standing. Do you have a credible threat? We have a credible threat. Okay, we're blowing past standing analysis. Preliminary injunction. District court's discretion. All right, let's see. The district court found Ms. Childs has not met her burden of showing likelihood of success. All right, on the first free speech claims. Okay. The key for our purposes is NIFLA. There, the Supreme Court considered a challenge to California law regulating crisis pregnancy centers, which are pro-life organizations that offer a limited range of free pregnancy options, counseling, and other services to individuals they recovered. The law required crisis pregnancy centers to disseminate a government-drafted notice on site. The notice read in part, California has public programs that provide immediately free or low-cost access to comprehensive family planning services, including FDA-approved care, contraception, prenatal care, and abortion. Okay, petitioners, in that case, crisis pregnancy centers, sued alleging violation. The Supreme Court reversed. The court first observed that precedents have long protected the First Amendment rights of professionals, and the court declined to treat professional speech as a unique category. NIFLA reaffirmed the Constitution does not prevent restrictions directed at conduct from imposing incidental burdens on speech. The court acknowledged that it afforded less protection for professional speech in two circumstances. First, our precedents have applied more deferential review to some laws that require professionals to disclose factual, non-controversial information in commercial speech, which is kind of true. And that also gets to like why, for example, drug commercials have to provide all those warnings, right? That's one of the reasons. So yeah, commercial speech can be regulated in some ways. In some ways, generally speaking, commercial speech is more intermediate scrutiny than strict scrutiny as a general matter. So if it's just commercial in its nature, it's more intermediate speech. And so this kind of makes sense. Like, it's like, okay, so if you're producing commercial speech, like an ad, we can, for example, require you to provide factual information such as, the FDA warnings that this drug may kill you. So that kind of thing. That's okay. All right. Second, states may regulate professional conduct even though the conduct incidentally involves speech. So to the extent you're regulating conduct, then maybe, and then you get into what's conduct and what's speech, which can sometimes get blurry, but you can regulate conduct even if it has some incidental impact on speech. And incidental being pretty key in that sentence, by the way. All right, so we read some other stuff. All right, and then they had Casey, where in Casey, this is not the, I don't think this, is this the famous Casey? Oh, I guess it is. This is the famous Casey. In Casey's, petitioners brought First Amendment challenge to Pennsylvania law requiring physicians to obtain informed consent before they could provide abortion. Supreme Court upheld the informed consent requirement as the only part of the practice of medicine subject to reasonable licensing. Okay. And court held in the requirement the physician provide information provided by the state. Court concluded the notice requirement NIFLA was unlike informed consent. It's like, yeah, informed consent is, do you consent to this procedure? That's pretty basic. The notice requirement's not the same thing. The notice requirement was not tied to the medical procedure at all. Yeah, fair. It applied to all interactions between a covered facility and its clients, regardless of whether the procedure was sought, offered, or performed, and provide no information about the risk or benefits of any procedures the facility may provide. Notice requirement did not qualify as regulation of professional conduct and necessarily could not fall within that regulation. Yeah. So, right. I mean, that makes complete sense to me. So, yeah. So the Ninth Circuit in that case held the notice requirement survives lower levels of scrutiny that applied to regulation of speech. And the Supreme Court reversed. They said you can't be forced to give out the information in that context. So, yeah, I mean, fair enough, right? Because it's like, look, this pamphlet that you want them to distribute, it's not required for the practice of medicine. Like informed consent is required for the practice of medicine. It's like, we want to make sure the patient knows what they're doing. And exactly what that looks like, maybe it requires certain things, but it goes to the nature of the practice of medicine. And here you just want them to hand out a pamphlet that's completely detached from any services you may be offering. It has no particular relation to any services you may or may not be offering. So it's completely detached. So it's like, no, you can't be forced to hand out the pamphlet. That doesn't make any sense. So I was like, I sort of get that. That makes sense to me. Okay. The court concluded, all right, the district court held that MCTL falls within the second NFIL conduct. It reached the conclusion, district court reason, this thing regulates the professional conduct of professionals, narrowly applies to their therapeutic practice, and any speech affected by it is incidental. This is talk therapy, though. This is talk therapy, and it directly relates to the kind of therapy you're allowed to talk about. So, I mean, trying to say this is conduct, it's like, as opposed to speech, I don't know how you're getting there, 10th Circuit. Only 171 people joining me. I'm surprised, man. Maybe my title wasn't spicy enough or something, because this is huge news. I'm surprised that there aren't a lot more people here, man, to be honest. I'm like, I would think that this would be massive. So I'm not sure what people are waiting for, man. This is a big deal. I wanted to go live with it right away because I thought it was such a huge deal, man. All right. The district court held it fell within the context. On appeal, they acknowledged their mental health, but insist that it regulates speech to the core, which I think it does. Mindful of the first principles, proceed to say whether it falls in the second conduct. The statute is part of the regulation of healthcare, and district court correctly found it applies to mental health, providing a type of prohibited treatment. But the treatment is in the nature of talk therapy. The treatment is in the nature of talk therapy. So you're not just trying to ban any procedure, you're trying to ban people talking. On the record before us, we agree the regulation relates to professional conduct that incidentally involves speech. Ms. Childs has advanced no contrary argument. Uh-huh. Okay. All right. So then they're going to discuss whether or not the statute regulates the profession for a while, which it does. Then they discuss whether talk therapy is medical treatment. They conclude it is. Pressing on. It's like, okay. All right. Then we say we must consider whether it incidentally involves speech or if the law regulates speech as speech. Constitutional right of freedom of expression is powerful medicine. We admit it may not be always easy to locate the point where regulation of professional leaves off and prohibitions on speech begin. But here the boundaries are precisely drawn and readily navigatable. That doesn't solve the problem. Like, we're not suing necessarily because it's vague. We're suing because it's unconstitutional, even if it's clear. It's like you have to draw the line in the right place. It's not enough to just draw the line. You have to draw it in the right place. As the statute makes plain, the regulation regulates the provision of therapeutic modality carried out by the use of verbal language. It does not regulate expression. It's the practice of conversion therapy, not the discussion of the subject by a mental health provider, that's prohibited activity. You're allowed to, well, that's even worse, though. That's like arguably even worse. It's like, yeah, you're allowed to talk about the subject, but only one way. It's like, yeah, you're allowed to talk about the subject, but only one way. So that's even worse. It's like if you didn't allow them to talk about the subject at all, that'd be bad enough, but you're into viewpoint now. Under the petition, a state couldn't ban a therapist from telling patients to kill themselves. Well, I don't know whether or not they could or not, because I don't know whether or not they could tell them to do that or not. I don't know. I'd have to analyze it separately. Can I just stick to the problem at hand and stick with that? It's like, yeah. I mean, you could probably you might be able to get there on a different idea. You could probably try to get to a ban on a therapist telling a patient that they should off themselves using, like, for example, intentional infliction of emotional distress as an idea, which, basically it's because it's speech that is so beyond the pale as to to be offensive, so you might be able to use like an IIAD idea to ban that idea. So maybe there's something there, but it's a very different problem. Ms. Childs may, in full compliance with the statute, share with her minor clients her own view on conversion therapy, sexual orientation, and gender identity. She may criticize this statute. May she refer minor clients to service providers outside the regulatory ambit. And once a minor child reaches the age of majority, they can provide conversion therapy. I'm not buying any of this. It's the same? I don't know that it's the same. I don't know that it's one for one. But, if you think it's the same, then fine. But I'm not sure that it is. Under this, you can't just regulate therapy at all? Well, no, again, it's not exactly that. It's a little bit different than that. You can regulate conduct, to be sure. You wouldn't be able to regulate speech. Maybe you're right. I haven't really thought it all the way through. Maybe you're right. I really haven't thought it all the way through. Let's see. Since generic, thanks for reasonable recommendation. Our conclusions consistent with Casey. Power of the government to regulate profession is not lost where the practice entails speech. That's true. It's never been deemed an abridgment of speech to make a course of conduct illegal merely because the conduct was in part initiated, advanced, or carried out by means of language. Yeah, this is a little bit more than in part, though. The statute incidentally involves speech because an aspect of counseling conduct by its nature necessarily involves speech. An aspect of it. Yeah, I'm not really buying any of this. A contrary conclusion would undermine the state's ability to require mental health professionals who engage in talk therapy to conform to generally accepted standards of the profession. Well, that's potentially a slightly different argument, maybe, because at least in that situation, it would be the profession saying that this doesn't make sense. So that might be a different argument than the state imposing it from themselves. Yeah, so it might be different if they said, you can't give therapy outside standards of the profession rather than we're just going to dictate the standards of the profession. The fact that it's coming from the state in such an affirmative fashion might be more the problem. Who's the plaintiff? A talk therapist in Colorado, Miss Childs, is the plaintiff. Yeah, okay. I don't really think I buy this argument. We recognize the 11th Circuit over dissent reached a different conclusion about similar law, concluding such restrictions are content-based regulation and must satisfy strict scrutiny. Because what the government calls medical procedure consists entirely of words. Pretty much. We are unpersuaded by this reasoning. And then they go all the way to rational basis. Wow. They go all the way to rational basis review. Wow. That's amazing. That's amazing. I mean, it'll survive rational basis, no doubt. It'll survive rational basis. I don't need to read an analysis to tell me why. Shit. Damn. Let's go back up to this. Let's go up to this petition. I believe we were on page 15. Yep. This is not the first time Colorado sought to regulate speech in a way that aligns with its views, but defy conscience. 303 creative. Nice. To be clear, Child seeks only to speak in a manner consistent with her religious beliefs. She does not seek to impose it on anyone else. She works with voluntary clients to determine the goals they have for themselves. And the clients voluntarily and specifically seek her counsel, yet they forbid it. Yeah. Yeah. Which sort of like goes against, even goes against the standards that they talk about in like LGBT circles. It's like, listen to the child, believe the child. It's like in this circumstance, the child themselves says, I feel gay, but I don't feel like I should. It's like the child's not saying I feel gay and I want to continue feeling that way. They're saying like, I don't feel like I should. So like, do we listen to the child and believe the child or don't we? Right. I mean, I mean, that's, yeah, this is going to be amazing. This is going to be amazing. It's not voluntary if your parents make you go. Maybe. whose consent matters, I suppose, to some degree. This is amazing. This is an amazing story. Yeah, this is an amazing story. Yeah, the 10th Circuit decision flouts the court's approach to drawing the speech conduct line. For nearly a century, this court has stressed the important question is what the challenge law regulates. If the law regulates conduct that was in part initiated, advanced, or carried out by means of language, the law might burn speech only incidentally. But the only conduct which the state seeks to punish is the fact of communication. The statute regulates speech. In short, the state must show that its regulation targets some separately identifiable conduct. Courts must consider the law's effect as applied in a very practical sense and not where to follow whatever a state law professes. If the law regulates conduct generally, that does not give states a free pass to regulate speech specifically. Yep. In Holder, the challenge statute prohibited conduct generally, providing material support. But target speech is applied to plaintiffs who want to give those organizations advice. Here, too, the government characterized the protected speech as conduct, but the court rejected that word game. The only conduct triggering coverage under a statute consisted of communicating a message, and that was speech. So it's pure speech, man. Pure speech. Yeah. Colorado law prohibits a category of persons from using the words about sexuality and gender. Worse, it prohibits only certain viewpoints. Only if the counselor's views are grounded in a particular viewpoint does the law apply. That is an egregious violation of the First Amendment. And embedded in the 10th Circuit reasoning are the seeds of its own undoing. For an enforcement official to determine whether Childs is permissibly discussing her views, that official would have to examine the content of the speech. But as in drawing a line, it's distinguishing between permissible and disfavored viewpoints. Yep. What a great case this is going to be. This is going to piss a lot of people off. And you can put this on your calendar for about 12 months from now, give or take. This is going to piss a lot of people off. Yeah. Amazing. Amazing. All right. That's pretty cool. That's pretty cool. I think that's pretty amazing. And this is going to piss a lot of people off. But I think I would have to say that I probably agree with the petitioner. Talk therapy is by its nature talking, and it's regulating speech. And to say it's conduct seems problematic at best. And you can't regulate certain viewpoints. And whether or not that means that that there couldn't be a law that would prohibit a counselor from telling a patient to off themselves, I'm not sure. Maybe. Although it might arguably be malpractice at that point, and you can regulate malpractice because, like, what would be the problem there, I suppose, would be like, what is the therapeutic benefit of that, right? So how does it achieve a valid medical end? Unless, of course, we're in Canada or something where they have, the ability to end your life. So, but the United States doesn't really do that. So the United States doesn't really recognize, voluntary offing yourself. as a valid practice of medicine. So how would speech that encourages a patient to off themselves further from the United States point of view a legitimate medical end? And it wouldn't. So yeah. That doesn't make sense. And would a state be able to do the opposite, say ban counselors from encouraging transition because it harms the child? I mean, to be fair, this would have to swing both ways. I mean, for it to be logically tenable. That's also a good question. And so, okay, well, that would be interesting. So you would have to root the easiest way to do that, it seems to me, you'd have to root your regulation in the legitimate medical end. And could a state, for example, say that it's not a legitimate end for a child to transition? And if they can say that, can they say the opposite of that? That's very interesting. Very interesting questions, to be sure. Very interesting questions, to be sure. And who, to some degree, determines what a legitimate medical end is? Because the regulation of medicine is traditionally the state's regulation. So very, very interesting. I don't know. Good questions, though. Good questions. And I appreciate the question because it's trying to make me apply my principles both ways. And I appreciate the question because it's making me try to apply the rule both ways, because I like rules, as you guys know. So it's like, okay, what exactly is the rule here? I'm like, okay. It's like, well, for the you should kill yourself idea, maybe we can root it in it's not a valid medical end. Maybe we can root it in that. Maybe that works. It's like, okay. For the you can't tell kids they should transition. So a kid comes to you who says, I'm gay, LGBT, whatever. You can't encourage them along that path. You can't give them that. All right, so how do we do that? Well, we would again try to do the same thing, right? Say it's not a legitimate medical end to try to transition a kid. Okay. It's like, okay, but if a state can say that, can they say the opposite of that? And if not, why not? And who gets to decide? So, interesting. I don't know. I mean, I could certainly see how a state could say it's not a legitimate medical end to try to transition a kid. They could say, for example, that I think they could reasonably say that the studies, for example, are at best inconclusive and in some cases contraindicating with relation to transitioning kids. There's a lot of information that would lead a state to say that's not the valid practice of medicine. This in favor of the proposition it is the valid practice of medicine is fact that, like, the American Medical Association and everyone else on the face of the earth seems to like to pretend that it's the valid practice of medicine. And it's like, if that's not sufficient, it's like, what is, Yeah, exactly. And the government can't force it as speech. Can the licensing board deem it harmful? That's exactly what we're talking about, right? That's exactly what we're talking about. Because it's like, how do you do that? And can they do the opposite of that? And if not, why not? Right? So if the board can say, that it is not valid to try to transition a kid, even if they want it? Can they do the exact opposite of that? And if not, why not? Why can they only do one and not the other? See, that's sort of the problem, right? It's like, how can they do the one and not the other, right? And so if they can do the one, then they can do the other, in which case Colorado's statute is valid. So, because they don't think it's a legitimate medical end. So, all those things. What a brain twister this is. What a brain twister this is. You guys are making me think pretty hard. The medical board says you can't promote supplements rather than drugs. Well, the drugs is the drugs is easier. The drugs is easier than the talk therapy, because there you're getting more into conduct because you're actually doing something. You're actually injecting them with a drug. So regulating the medicine is a lot easier than regulating the talk therapy. So I think that would be a lot easier to say, oh, this is not valid. It's not valid to provide medicine, because medicine it's more conduct, right? We're not doing speech. You know, like hypothetically, you could do it without any speech at all. I mean, it'd be a little weird, but you know, at least hypothetically, you know, there's nothing that implicitly requires like there to be any speech in the treatment. You know, so it's much more conduct than speech. So regulating the medicine is a lot easier. We're just talking about pure speech right now. What's the difference between a drug and a supplement? None. They're both objects. They're both things. There's no difference with respect to the regulation. There's none. Yeah, because a supplement is still a action. It's still a action, not speech. So there's no difference. The state could choose to regulate them differently, but there's nothing that they could regulate them the same. So yeah, there's no difference. There's no difference between a drug and a supplement, not fundamentally. The supplements aren't usually as regulated as medicine, but there's nothing that makes that so, except the fact that's the way they treat them. There's nothing fundamentally that makes it so. They could be as regulated as medicine. That's possible. So, or the other way around, the medicines could be treated like supplements. That could be true too. There's nothing fundamentally different. They're just different categories that the government, for most purposes, treats separately, but they don't have to. You know, they don't have to. Yeah, supplements are not as regulated as drugs, but that's because the government doesn't want them to be. Like, there's nothing fundamental that stops that. If they turn it around tomorrow and said supplements are now regulated the same as drugs, they could do it. There's nothing that stops it, because there's no fundamental distinction. That's what I'm trying to say. Hopefully that makes sense. All right. I think I'm going to sign off and try to make an edited story about this. I haven't done an edited story in a while, and I think maybe it would be better as an edited story. So I'm going to try to see if I can put together an edited story about this. And maybe I'll delist this too. I don't know. I'm trying to decide if I want to delist this or not. Only 245 people. I don't know if I'll delist it. What are my pronouns? Fuck and off. Those are my pronouns. All right, I'm going to go ahead and sign off for now. And I'll get back to you guys on this. Very, very interesting. Very, very controversial, to be sure. Talk to you guys soon. Bye-bye for now.